Good afternoon, Popok, and all of the people who are joining us right now to hear about how the final day of testimony and evidence came in, day 20 of the Trump trial, being prosecuted by my old office, the Manhattan DA's office. It was a short day in terms of testimony. I want to hear your perspective on the defense calling Bob Costello, who briefly tried to get Michael Cohen to hire him as a lawyer. And Michael Cohen apparently didn't trust him enough to be honest with him or share any details with him, and didn't ultimately end up hiring him. And I think that's what at least Michael Cohen testified about. But on the stand, Mr. Costello, I think any doubt that the jury had about that, I think he eliminated any doubt, and it really backfired on the defense by calling him. But we'll talk about that, Popok. I want to hear your perspective. And then the jury, the judge let the jury go home, and it told them again, no Googling, no talking to anybody. Just go home, and I'll see you on Tuesday. I almost said see you next Tuesday, but I didn't. It said see you on Tuesday. And they're coming back for summations and charge. So this afternoon was a charge conference that's been going on, and they have been going over the various legal charges that the judge is going to read the jury. In some ways, it's the most important part of the case, is the jury charge. It's what will the jury be told is the law, and what are the various things that they have to consider, et cetera. It's also one of the number one areas that cause trials, convictions to be reversed, okay, is giving them the wrong charge or somehow getting that wrong. So it's really important to get this right. I'm sure the judge, who's a great judge, has been doing a ton of research and preparing for this. And lots of case law has been provided, et cetera. But the jury charge is being discussed, or was being discussed today. And on Tuesday will be the summations and jury charge that will happen after summations. It's also important for summations because the lawyers want to know, what are the arguments you're going to make? You know, what are you going to say either supports it or takes away and says, oh, they didn't, you know, if there's 5 elements to a crime and the jury finds that 4 of the 5 were met, the only verdict they can render is not guilty. They have to unanimously find each and every element of each and every one of the 34 counts of falsification of business records. So Popok, let's dive in and talk about what happened today. Talk about Costello. What did you think of the conclusion of his testimony today?
And ended the way it started, in flames and in tatters around the ankles of Donald Trump and his lawyers. It backfired spectacularly to have called Robert Costello for the sole purpose of trying to attack the credibility of Michael Cohen. Jury, that issue for me, and I think for the jury, is baked. They either believe Michael Cohen is telling the truth now, or they don't believe him. I think it's binary. I don't think they think, well, he's telling the truth now, he's not telling the truth now. Maybe 2018, as Michael Cohen put it so eloquently during his direct a long time ago, he was knee deep in the cult of Trump. Would have said and done anything to stay in that orbit, and even if it meant not telling the truth. Once that cult trance was eliminated, jail time will do that to you when you go to jail for somebody. I think since then he's told the truth, even when it's against. It doesn't have him covering himself with any glory. Did you steal from Donald Trump? Sure. I took an extra $30,000 because I thought he screwed me on a bonus, and he still hadn't paid me back for Stormy Daniels. That's something that a jury of New Yorkers are like, yeah, that sort of makes sense. The problem for the defense, and Costello being an example of it, a symptom of it, is this disease that they're infected with, is that your old house, your old shop, the Manhattan DA's office, took the facts that are not in dispute. Stormy Daniels getting paid off with $130,000 through Keith Davidson and Michael Cohen, not in dispute. Karen McDougal, same thing. The catch and kill program, that it existed, that there was a conspiracy that was, at least in Todd Blanche's view, a talk between three people in order to do illegal things. We call that a conspiracy in our business. Some of these facts are just completely, both sides have to agree to them. Whether Donald Trump really had an affair with Stormy Daniels, while interesting, doesn't really matter. But how you take those facts and how the jury is being asked to hang them in an organized fashion on some sort of theory of the case, and whose theory is more logical, more internally consistent, the prosecution's or the defense's? And it's got to be the prosecution. They were told, these are the facts you're going to hear. These are the witnesses you're going to hear from. This is the evidence you're going to see and hear in opening. And that's exactly what the prosecution did. They delivered in every way, shape, and form, including through Michael Cohen, David Pecker, Karen McDougal, Stormy Daniels, the in-house people for Donald Trump, the financial controller, payroll people, you name it, they delivered. They cashed the checks that they wrote. On the other side, the defense in their 20-minute opening just said, oh, so funny, a Trump Tower conspiracy. Never heard of such a thing before. That was basically 20 minutes of what Todd Blanche did. And then they hoped and prayed that they'd be able to destroy Michael Cohen. Unfortunately, Michael Cohen did, on balance, well, admitted things he had to admit to, didn't come off as a liar, didn't lead the jury to be laughing at him the way they're laughing at Bob Costello. They're not eye-rolling Michael Cohen. They're smiling and nodding in inappropriate moments because Michael Cohen, they're believing Michael Cohen, at least most of the jury, at least the ones that are not poker-faced. By contrast, the only two witnesses put on by the defense was Costello for an hour and 10 minutes, and a paralegal that works for Todd Blanche, the lawyer for Donald Trump, to talk about how he combed his way through Verizon telephone bills to establish phone calls between Michael Cohen and Costello. At this point, the jury's got to be thinking, why do we need to hear from Bob Costello? And why is Bob Costello insulting our boss, the judge? Because that's how a jury starts to feel if they appreciate the judge, admire the judge, and all of that. And the judge has treated them well, and the care and feeding of the jury is very, very important at that moment. And then you got Costello, who decided that he's going to be not a witness with knowledge. He's going to be an advocate. And he's going to try to act out the way that Todd Blanche acted out against the judge and got reprimanded a number of times, the way they did it with Chris Keiss at the New York Attorney General's case that backfired spectacularly then. And so because he's been an advocate and a shill for Donald Trump for so long, Costello came in with that mentality and started to literally take on the judge, to the point where, as we reported yesterday in the morning, the judge admonished him and basically threatened and said, you're in contempt. And if you do it one more time, I'm going to strike your testimony. But that carried over in front of the jury when the jury started laughing, not in a good way, with Costello's testimony, especially I thought Susan Hoffinger, who did, I thought, okay, a good B+ with, if we're giving grades for Stormy Daniels, I thought she was A++ in cross-examining Costello. I mean, it was like a live autopsy where she just ripped out his heart and showed it to him. And I don't think it was almost as if the other side didn't know about the emails. Costello writes a lot of impertinent emails about his clients, apparently, to his partners. I've had partners for 32 years. I've never written and called my client an asshole, which is what he did about Michael Cohen, and then reveal that his true client was one guy named Donald Trump, the most powerful man in the universe in the United States. And so when he was faced with these internal emails that showed that he was truly aligned with Donald Trump against Michael Cohen, and he could care less about Michael Cohen, then the mask slipped off and all was revealed. And that's when the jury started laughing at him. That's not a great witness to end on. People commented, I saw MAGA media commenting about, it wasn't great to end on Michael Cohen either. I disagree. And I want to hear your view. After 20 witnesses with the bookend of David Pecker and Michael Cohen and everything in between and all the evidence in between, I think this goes to the prosecution. And then the last thing on the jury instructions on the charge conference, those charges and the way they will be sequenced perfectly, I'm sure, consistent with New York law to avoid an appeal, is an advantage, I think, for the prosecution. It's just the way the elements are and the way they're going to be explained to the jury. And the second crime issue that didn't have to be charged, it didn't even have to be proven, just in furtherance of, is, I think, an advantage to the prosecution. I'm not talking about shifting burdens. I'm just talking about that when the jury, now with the facts and the theory of the case and the final summation, closing argument by the prosecution, then go in the back of the room and apply them, I think this is going to be a verdict for the prosecution. That's me. What do you think?
Look, I agree with you that Costello really backfired on the part of the defense. Any ground that they made with Michael Cohen, and I actually don't think they made a lot of ground. Looking back on it, Michael Cohen is a cross-examiner's just dream, right? He's got a conviction for lying. He's served time in prison. He has an axe to grind and a grudge against Trump. The guy has talked about the case more times for more hours. I mean, thousands of hours, I bet there are, of podcasts, and there's books all about the subject of his testimony. If that is not just the perfect opportunity for someone who's going to cross-examine him to look for any little inconsistency, to look for anything to catch him in a lie. I mean, you never have that, right? Half the time you're cross-examining someone, you know nothing about them other than their name and some paperwork that the government has given you that has maybe some prior testimony or something, and that's it. It's hard to cross-examine someone, especially when you don't know much about them. He has talked about this case over and over and over and over and over again, right? I mean, that's what he does. And so it's hard to tell a lie the same way twice. But if you're telling the truth from memory, it's going to come out the same way every single time. And the fact that the defense didn't make more hay out of Michael Cohen and the cross-examination is a crushing blow for the defense. I mean, what a missed opportunity. The two areas that they said that the grounds that they covered that the media was breathless in reporting was an October 24th phone call that the prosecution quickly debunked by showing a photo taken from a still photo taken from a video 4 minutes prior to the call, showing Trump and his bodyguard David Schiller were together, thus corroborating Cohen saying, yeah, I called Schiller's phone to talk to Trump. There were text messages that Cohen was also texting with Schiller about an issue he was having with a 14-year-old. Makes sense. He's a bodyguard. You would text him about a 14-year-old harassing you. But the president of the United States, 2 weeks before he's about to run for president, has a lot of other things on his mind. You're not going to call him. You're the fixer, right? You're going to fix his problems. He's not going to fix yours. So you were calling to tell him about the fact that you're fixing the Stormy Daniels things and fixed it. So it makes all the sense in the world by common sense. And the fact that there was this photo showing, yes, they were together. Cohen was right. And by the way, that call isn't even essential anyway. And the only other place that they seem to have made a little bit ground was when they were like, aha, you stole from the Trump organization. Well, first of all, it came out on direct. And second of all, this isn't some big aha moment. Michael Cohen wrote about it in one of his books, Disloyal. So, the guy has always consistently said the same thing, including bad things, right? He doesn't hide them. He doesn't sugarcoat them. He talks about all the bad things that he did and he admits them. And they weren't able to catch him on a single lie. So that was a huge missed opportunity. Were they able to, remind everybody of what kind of person Michael Cohen was at the time that Trump valued the qualities that he brought to the table? Yes, they were able to do that. And I'm sure there were some jurors who had a distaste for parts of Michael Cohen, if not all of it. You don't have to like Michael Cohen. You don't have to want to have dinner with him. You don't want to have to be best friends with him. Is enough of what he said corroborated, and everything he said corroborated, or not. And I think, again, any hay that they made out of Cohen was totally undone by putting Costello on the witness stand. Bob Costello isn't a reformed, changed man, you know, since he did these things for Trump. He is still clearly in the Trump orbit and still part of this group that just, no matter what, follows him. And he just blew up on the witness stand. His emotions got the better of him, so he was not objective. He was not sort of an objective witness who was just testifying, to the facts. He was clearly emotional and lost control, and the judge had to clear the courtroom. That's not a good look, right? That certainly doesn't make it seem like the guy was just being objective, number one. And number two, there were all these emails that proved exactly what Michael Cohen said, which was, "You never were my lawyer and I didn't trust you," and B, consistent with the prosecution's theory of the case. And I love what you said about Susan Hoffinger, that she did a masterful job cross-examining him. And I'm not surprised, because Susan Hoffinger is a trained defense attorney. Yes, she was a prosecutor briefly as a young lawyer, but she has all her chops come from being a defense attorney. She's one of the more respected criminal defense attorneys in New York. And I'll tell you, Alvin Bragg was smart to hire her to be an executive. But that's what that girl knows how to do. She can cross-examine someone, and she did a great job. Yes, everyone criticized her for asking leading questions of all the other witnesses, but that's what she knows how to do. So she's a great lawyer, and I would suspect that Josh Steinglass is going to give the summation, and that's what he does. He's the trial lawyer. He will wrap all this up in a bow.
Yeah. And by contrast, as I said at a hot take previously, well, two things. One, you had a very good point about in a midweek that you and I did together. Let me just think if I can remember what it is. It'll come back to you. It was a good point. I'll remind you that you made it.
I do that all day. It happens to me all the time.
Yeah, no, it'll come. I had it. I was like, well, on tip of my tongue, but I'm gonna do something else first. On Susan versus Todd, which is what it ended up being, Todd Blanche. The problem with Todd Blanche is, and I've litigated against this before, he hasn't been in a courtroom in a long, long time doing a trial. He hasn't done a live witness in a courtroom in years. He was 13 years in the U.S. Attorney's Office like 10 years ago. And yes, he was like, I think at one point he was the head of the criminal division at some point. And then in private practice in his major white shoe law firm, before he ended up opening the captive law firm of Donald Trump called Blanche and Associates, whatever it's called, that's housed in 40 Wall Street, one of the buildings Donald Trump owns. I'm not sure he's done an evidentiary hearing or a trial in the last 2 or 3 or 5 years, if not more. And I've been against lawyers who lose their fastball and get rusty about how to handle witnesses. And with all the pressure and the eyeballs burning a hole in the back of his head from his client, Donald Trump, you got to, this is what you have to do. And whispering in his ear, I'm sure in all the prep sessions about how to do it. It was just, he did not have an artful surgical way to do Michael Cohen. Yet, despite the fact, as you mentioned, it was a target rich environment. It was like too much that you could have done. And Michael, I think the jury has believed, whether it's this redemption, mea culpa, the books, the podcast, that there's 2 Michael Cohens. There's the Michael Cohen that curried favor, was in the orbit of Donald Trump. And there's the Michael Cohen after. And he's believable after, as you said, because of the consistency by which he's been testifying. And he's been corroborated and re-supported and re-corroborated over and over again. And that was the beauty of the presentation by the prosecution. I mean, not to pat everybody on the back yet. We don't have a verdict. But in all the witnesses, one way or the other, not named Michael Cohen, supported Michael Cohen. So by the time they got to Michael Cohen, those bells had already been rung for the jury. They already knew who he was. It was already baked into their analysis. And so, and for me, Hoffinger, I thought did really, really well. And to end right there, and now let's just talk quickly about what's coming up. Because you and I, in the morning, we got it right last night too, about directed verdict, denied, Motion for directed verdict will be denied. Charge conference happens, and the judge figured out the Rubik's cube of the Memorial Day weekend holiday Wednesday dark thing. And as you predicted, and I know from my own practice, lawyers need to have their closing arguments and summation right near deliberation. And so if you need to then end the trial early, boom, and tell the jury we'll see you after Memorial Day, that's the reason. Because if it was a bench trial, it would be like, well, do your summations and we'll get together another time. But with a jury, you gotta do your closings right before the jury deliberates. That's the only fair thing. And so that meant 4 days off, even if it meant wasting a couple of days this week, because they'd never be able to do closings and then go right to deliberations with this jury. And then, the judge told the jury, be ready to start deliberating and being charged by Wednesday. And I think that's going to happen. And then you and I will be with Ben. We'll be holding a dead pool about how long this jury is going to be out. Is it going to be, depends on when they get it, but is it going to be breakfast order, coffee, who got the tuna salad verdict? Or is it going to be, a day and a half? We come back the next day and talk about it. That's what you think, right?
Oh, 100%. This is not a quick verdict. Either way,
you think it's an 8 hour plus?
If it's a quick verdict, that's not good for the prosecution. I mean, in my opinion, they're going to go, and so they are going to go out overnight. If they go out too long, that's not good either. But I think this is.
Well, what if they get it Wednesday morning? You don't think they could get it done by Wednesday night? Tight.
Charge is going to take an hour and a half.
But won't he be able to do that on Tuesday? Like if they do, even if Todd Blanche or Susan Necklace, maybe Susan Necklace closes, but even if they take double what they took last time, that's 40 minutes. The prosecution will probably take, what do you think, an hour and a half? 2 hours?
I think I think the defense summation is hours. It has to be hours.
You think so?
Oh yeah,
right.
They have. If they don't, that's nuts. I mean, this they should do at least 2 hour summation. I think.
Didn't you think it was nuts that they did a 20-minute opening?
No, opening is different because you don't know what the evidence is going to be, right? So if you're the defense, and you want to keep your options open, right? But now this is their time to argue. Yeah, I think they're at least a 2 hour summation for the defense, and I think equally a 2 hour to 2 to 3 hour summation for the prosecution.
I've done white collar criminal. I've never seen a 20-minute opening, so let's just say they do their 2 hours, and the prosecution, your old office, what do you think they do?
3 hours.
So that's 5 hours. So that's and the charge that takes care of Tuesday, right? Yep. So why can't they start deliberating Wednesday morning?
They could. Yeah. They might charge them Wednesday morning. I think summations are Tuesday. I think they're going to charge Wednesday morning, and then say he's going to want to charge and send him out, right? Like you don't want any distance between the charge and when you start deliberating. Yeah. So I think that comes Wednesday. So let's say they start 9:30, 10:30. They start deliberating around 11.
Thursday
12,
before lunch.
1, 2, 3. I think it goes overnight. I don't know. They're going to go. This is the thing. This is not an all or nothing. They're going to go through count by count, and they're going to be like, okay, this check. This is typically how they do it. They go to count one. Count one is about this check on this date. Okay, we want to see that check. Okay, I want to now remind me what's the evidence about that check. When did this happen? Okay, how does that fit? They're going to do that with each and every one of those.
You know why I think your timing is right is because in the way you've described New York criminal practice, as opposed to Fed and other places where I've practiced, they're not going to have the pile of evidence in the room, and they're going to have to ask for everything. And so that delay.
Well, they can ask for all the evidence. They can say, they can.
Oh, they can?
Yeah. So typically what happens is they'll say, they'll beep and they'll say, can we have all the evidence? And then they'll beep again and say, can we have, every once in a while, can we have a TV to watch the tapes? Yes. Can we have a tape recorder to play the whatever? Whatever they're going to want, they're going to ask for that stuff. They're going to ask, they're going to want to see everything. And then I bet they have some readback. I bet there's a lot. That's why I think it's going to take a couple days.
Yeah.
Is I think there's going to be readback, and readback is the slowest thing on the planet because
the
it
court
takes
reporter does it, right?
well, and it takes an hour before, like, what happens is you get a note, they'll buzz twice, you'll get a note, or not buzz twice, you buzz once, you get a note, and
Buzz
yeah,
twice is verdict, right?
yes, exactly. You buzz once, there's a note that gets sent out, and then everybody reads the note, and they're like, oh, they're asking
Oh,
for
shit.
the portion of someone's testimony. They're asking for the portion of Michael Cohen's testimony that talks about October 24th. Well, the prosecution will say, well, that part is in 6 different areas on direct, and you can't really parse that out. And so since it's in 6 different places, maybe we should have the whole direct read. And the defense will say, no, we don't want the whole direct read. So then they'll argue back and forth over what's responsive to the note. The judge will decide, and then the court reporter has to find that part of the testimony.
Right.
And you're all sitting around twiddling your thumbs until you can call the jury back in the room to then read in real time whatever it is.
You've convinced me. A day and a half. Just the procedure, the logistical procedure.
Yes.
Because I've always had in civil cases where they just have the boxes and they go hunting through. They got the jury instructions. They got the boxes. Maybe they ask a question or two, but not like this. Especially, why this is, you're mapping it out, I think accurately, is also because there's 2 lawyers on the panel. And maybe they're not the jury foreperson, but they'll kind of keep the jury honest about, we should do this and we should read this. And you could just see them not sitting there twiddling their thumbs, right?
You just reminded me of something, Popok. The 2 lawyers on the jury, getting back to Costello, they are going to be mortified by his behavior. Like, you know what I'm saying? They are going to be just
clown. What a clown.
I mean, that's going to be, so that's another reason why I think it backfired.
Yeah, I'm with you. I think if they roll over to, but the good news is, whether it's Thursday or Friday, there's going to be a verdict. I guess we got lost in the trees there for a minute. There's going to be a verdict next week, and it's going to be guilty or and then this issue. I guess know the issue?
Unless they hang.
That's true.
That won't happen next week. The judge will make them keep deliberating, and I bet he'll send them, if they can't reach a verdict and they start to send out
charge.
And if they start to send it, exactly, if they send out notes saying we're having a hard time, we can't reach a verdict, the judge gives them what's called an Allen charge, which is basically says keep deliberating, and it's a whole thing that he says to them to encourage them to continue to deliberate. And then he sends them back, and it's not until sometimes I've had juries get multiple Allen charges, and most of the time you get a verdict. It's not until they come back and say, we have irreconcilable differences. No matter how long we deliberate, we're never going to agree. And the jury hangs them. I bet he wouldn't hang them next week. I bet he'd give them the weekend to think about it. So I'm not 100% sure we'll have a verdict next week.
I had a trial. You like this one? I had a jury trial once where there was one holdout, and the jury wanted to kill her, and they wrote a note and asked if they could have the juror removed and replaced with an alternate. And the judge wrote, and the judge wrote back, "This is not Survivor. You can't vote her off the island."
Well,
no.
My judge didn't say that. Yeah, no, I've had that too. It's torture. And my husband once had a jury out for 6 weeks when he was a prosecutor, and it was ultimately a mixed verdict, some convictions, some acquittals, but 6 weeks the jury was out, and the judge kept him out for so long because they never said they couldn't reach a verdict. It was, they needed time to go. So I think there's probably going to be a verdict next week, but not 100%. A little bit, I just want to also talk a little bit about the 2 things. First of all, Don Jr. was in court today for the first time, right? So far, we've only seen Eric in terms of family members. And the other thing too is the jury instructions that the judge is going to be given. The judge was very much something we talked about when this case first came out, and everyone kept saying, well, what's the other crime? What's the other crime? The judge, they have to agree on it. And I don't understand. Don't they have to prove it, et cetera? And I kept making this analogy to burglary, that it's with the intent, and not about, they had to commit the other crime. And they don't even have to be unanimous on what the other crime was. And people thought I was nuts for saying that. But it turns out that is exactly what the charge is going to be, that it's just about unlawful intent to commit a crime. It doesn't necessarily have to, they don't necessarily have to agree on that. So I think that was a big, big win for the prosecution, to get that, to have it be spelled out like that, because that's what New York law says. And of course the defense didn't want that, right? The defense wanted it to be, them to have to commit to a crime and have the elements of the crime, and then beyond a reasonable doubt for the elements of the crime. But it's crazy, right? To say that someone might have a criminal intent, but they don't know exactly. Go ahead.
We hit the nail on the head 6 months ago. We said that second crime does not have to be charged. It doesn't have to be proven. And now it can be so inchoate that it could just be like anything, which is advantage prosecution. What about the lesser included offense issue we raised earlier?
No, no lesser included. Yeah.
Nobody asked for it?
Well, the statute of limitations run, you can't.
Well, no, you said there could be waiver and request.
Oh, yeah, nobody asked for it, no.
Okay. Ooh, we got a lot to do between now and Tuesday.
Yes, absolutely. Okay, so anything else? Anything else that before we drive everyone over to political beatdown, which is going to be happening right after this. That's what we always do in this live feed, is everyone who's here, and thank you everyone for being here. We love that people join us live, and that you're so active in the comments. I look at the comments while I'm speaking, and sometimes it distracts me. So sometimes I don't like to look at the comments. Sometimes the comments crack me up and I start cracking up, but so we do appreciate the active participation. And so are we ready, Salty and Jeremy,
we're going to throw it to political beatdown? Let's throw it over to political beatdown.
To throw it. Okay. So everybody stay on. We're going to go right to political beatdown. And I guess we won't be back, or Ben and I won't be back until next Tuesday. So I just have to say it. See you next Tuesday, everybody.
By the way, that comment, Trump used that against one of the lawyers, Robbie Kaplan, in his deposition. I thought you were actually referencing that. But I'll see you tonight for dinner. Bye.
Bye.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.